Moving on, now in an exclusive conversation with CNN News 18's legal correspondent Ananya Bhatnagar, retired Supreme Court Judge SK Kaul recommended Truth and Reconciliation Commission for human rights violations in Jammu and Kashmir since 1980s. Listen in to that exclusive conversation.
You had given a very extensive judgment in the 370 case. The case though was on constitutionality, but your judgment brought a humanitarian angle to it. It was the plight of the Kashmiri people who faced those violent times in 89 and 90s. You asked for setting up a Truth and Reconciliation Commission. Do you think isn't it too late for that to happen? It should have happened at that point of time itself.
I believe this is the time. If it has not happened before, it should happen now. See, in South Africa also it took many years of turmoil before it was established, because by the time they got their independence, that is how it was. So there are two aspects to this. One aspect is the circumstances in which a large section of population, more than 4.5 lakhs, was compelled to migrate. And that issue has never been addressed, I believe. Nobody tried to get to the bottom of it, why it happened, and it was brushed aside. Then you had the army coming in, trying to fight a war. And when the army fights a war, paramilitary fights a war situation, things happen and did happen. So there's another section of society which lived there, which has some grievances. It arose recently also some problem. So Truth and Reconciliation Commission objective is that if you are saying, well, it's too far in the past and now we can't provide a judicial remedy to it or a criminal remedy to it, at least acknowledge something wrong has occurred. That acknowledgement itself is a healing process. So, and that's how it worked. It worked beautifully in South Africa.
Well, in the same conversation, retired Supreme Court Judge SK Kaul also spoke about collegium system of recruitment for the Supreme Court. Listen in to that as well.
A lot is being talked about the collegium very recently. In fact, debate sparked up in the last few years with regards to, what is better. There was an NJAC that was brought in, but the collegium system still exists. But many questions are raised on the collegium. Do you think it needs a rework? There should be some changes that should be made to the collegium system or the judicial appointments.
See, the collegium system came into being in 1990. It had a purpose. It has operated fine. But the political spectrum thought that they wanted a greater say, and they were not comfortable or not happy with the system of appointment of judges through the collegium system. They brought in a law. Now that was struck down. So the challenges to the collegium system working have really come post the NJC judgment, because the political dispensation has not, over a period of time, been really able to accept it. They feel they have a role to play, and when there are dominant majority governments, they all the more feel that they should have a bigger role to say in the appointment process. Now, collegium system endeavors have been made to tweak it, improve it, different methods were thought of, and many people have contributed towards it. The question is whether the political class is comfortable with the collegium system. That seems to be a little problem. But the current law is the collegium system. Therefore, my belief that till the collegium system continues, which is the law, then it must operate as envisaged.